Afternoon, everyone. Welcome to today's presentation. My name is Kirat Sandhu, and I use she, her, hers pronouns. I am the training coordinator for the Indiana Coalition to End Sexual Assault. Today's webinar is the second of 5 in a series developed by a group of people with disabilities, disability advocates, the Indiana Coalition to End Sexual Assault, the Indiana Coalition Against Domestic Violence, and multicultural efforts to end sexual assault. We have collaborated to bring you this series focused on disability over the course of 2018 in the hopes of increasing skills, knowledge, and use of best practices in advocacy and prevention that are inclusive of disability. It is our hope that this series will serve as a catalyst to spark much-needed conversations about improving Indiana's systemic response to pervasive violence committed against people with disabilities. Today's presentation will feature multiple trainers who are content experts in this work. Before we dive in, I would like to address some aspects of the technology we'll be using today. You will see that your mic was automatically muted when you entered today's webinar. We highly encourage you to ask questions, and in order to do so, you will need to use the questions pane, commonly found on the right side of your screen. Any messages you send will only be seen by me, as there is no group chat feature. Please let us know which speaker the question is addressed to. At the end of the presentation today, I will read these questions out loud for the entire audience to hear. Please let me know if you would like your question to be read anonymously without your name attached to it. Additionally, please note that today's webinar will be recorded and made available along with these slides at indianakesa.org under the Archived Webinars tab later this afternoon. And one final note, as many of you may have probably noticed, a paused webcam may be appearing at the top of your screens. You can use the gray drag-up bar to hide that screen for now if you'd like. Kelsey Cowley, whose webinar screen that is, will be playing her webcam for us later today, and you can then maximize that screen when she chooses to share it with us. And at this point, I would like to go ahead and introduce our first presenter. Sierra, the floor is all yours.
Thanks, Kirat. Hello, everybody, and welcome. My name is Sierra Olivia Thomas Williams. I'm Miwok of the El Dorado Rancheria. Those are the Umne of Tumele Nisinan Miwok. I use she, her, and hers pronouns, and I'm a person with a disability. I am also a violence prevention specialist at Indiana Coalition Against Domestic Violence, and this is our second webinar in a collaborative exploration and introduction to intersections of disability justice and violence prevention. And I really feel like it's important to say here that we have chosen to go broad versus deep. And I'm so excited to have this conversation today. We're welcoming guests Melissa Keys, who's the legal director from Indiana Disability Rights, who is coming off a major legal victory this month. And she is going to talk to us about what guardianship is and how it works. And we are also welcoming Kelsey Cowley, the president of Self Advocates of Indiana, who is doing great work in sexual violence prevention and culturally competent and inclusive healthy sexuality at the state level. So before I pass the mic, I really wanted to set up the context for our conversation. Why have we paired a discussion about guardianship with a discussion about sexual consent? Whoops. Oh, where's my, oh, there, it's missing the one of the slides, the first slide, this one. Okay, well, this is interesting. Okay, so there, can you find it, Kirat? Okay, so I'm just going to start talking about this. That is a useful, okay, my bad. All right, so when you have an opportunity, you will see two images that I believe set the context for this conversation. There it is, yes. Thank you so much. These two images set the context for this discussion, and I am going to go ahead and just jump right in the deep end here. The Planned Parenthood image at the left describes social sexual consent as freely given, reversible, informed, enthusiastic, and specific. And on the left, wait, that's the right, the recent NPR story which is a very important story, a part of a series called Abused and Betrayed by Joseph Shapiro. These represent the national narrative about sexual violence prevention, and these are oversimplified. Through healthy relationship and healthy sexuality education, prevention practitioners teach that consent is an ongoing negotiation among participants. So this national narrative suggests that rape is a knowledge problem and that it is about bad choices. And if people only knew about social consent or what healthy relationships and healthy sexuality looks like, that they would just make the right choice, which I feel like it's important to say nationally, that right choice is promoted as abstinence until marriage with the old definition of marriage in mind. So healthy sexuality education for people with intellectual and developmental disabilities should come from within the population, bringing margins to center and not from well-meaning adults who infantilize their students. And I just want to make it really clear that I know not all sexuality educators do that, but I have met plenty of well-meaning people in my field who think people with intellectual disabilities are not capable of teaching culturally competent sexuality education to their colleagues, peers, and friends, and that is a systemically supported belief. So locating the problem of sexual violence with individuals distracts us from the fact that rape is a population level problem that requires population level solutions. This conceptualization of sexual consent is that it is a social contract determined by the assumption that we all have full autonomous rights and that we are empowered to make our own choices, even when they are not the best choices. And I do want this version of consent for everyone. However, this just really is not an accurate depiction of reality for many humans in our nation who have been stripped of their rights through incarceration or through guardianship. This lovely idea of consent is not enforceable. And what I mean by that is this is not how rape is determined by law enforcement officers and prosecutors who, in my experience as a crisis advocate for 17 years, often choose not to pursue cases in which consent was revoked. And I do look forward to hearing from anybody who disagrees. What are the consequences of when we as violence preventionists teach this idea of social sexual consent without also noting that this idea of consent is not supported by environments where sexual violence is just not tolerated, where sexual violence is not an option someone feels the need to choose, and where equitable behavior in relationships and even among strangers is a desirable option? This idea of social consent will not be legally upheld right now, and that is some systemic dissonance. So yes, we want accessible, accurate, and culturally competent sexual health education across the human lifespan, and that is not happening. And there are systemic legal barriers that prevent that. And a lot of ands, we know that decisions are not made in a vacuum. There are power dynamics at play in the conditions in which all people make decisions. Joseph Shapiro, for example, did not talk about the legal barriers of guardianship for people with intellectual disabilities that often removes the choice to even attend a class like that. Some humans are disenfranchised from making choices about sexual practices and sexual reproduction and sexual health education as adults, despite being enthusiastic, yet plenary or total guardianship prevents it. This national narrative is overly simplified. It locates the problem of rape culture and its solutions with individuals, and it supports the status quo of systemic oppression, ignoring completely the problem power over to control populations at all levels of the social ecology. Social consent is a false solution to systemic state-sanctioned sexual violence. And I jumped in the deep end, and I feel like I just grabbed an electric fence. So in case my grandparents are listening, I feel like I should say there's a funding disclaimer at the end of my slideshow. Excuse me. There we go. I'm sorry. The social contract idea of consent is not how consent is codified in the Indiana Criminal Code. Rape is defined by the absence of consent, but consent is not defined in this code. So when we look at the definition of rape in Indiana, which requires capacity, and a simplified definition of that is just having enough information to make choices and also to recognize and resist coercion. I think about the fact that there is no imperative upon school systems to provide access to and opportunity for comprehensive, culturally competent sexual health education, which would certainly help develop capacity for making informed sexual choices. So yes, consent can certainly reduce the risk for harm, but it cannot guarantee safety, because as a fierce advocate and friend taught me recently, what is a harm for one person may not be perceived as harmful by another. And the biggest issue, particularly with people with intellectual or developmental disabilities, is the fact that consent presumes that we can negotiate a level playing field. And under plenary or total guardianship, I do not know if that is true. People who lack legal capacity to consent still want and need information and the dignity to take risks. This idea of dignity of risk is a term that a colleague within the disability services field describes as the option to make choices and make mistakes and learn from those mistakes. And this is not available to people with intellectual and developmental disabilities quite often. So a primary barrier to sexual autonomy for people with intellectual and developmental disabilities is the intentional isolation from sexual health education and the way in which guardianship is used to strip individuals of their rights. This is one of my teachers of disability justice and advocacy. This is Lydia XE Brown, who through their work in disability justice has taught me that ableism is a system of power relations. Brown argues that disability is an entire way of thinking and doing that harms people who are considered disabled. And I would add, and Brown also talks about this, that disability itself is a category within the public health model that is defined as a state of being caused by disease or injury and not natural human variation or aging. Brown, in their amazing presentation, which I highly suggest you check out, called Beyond Service Provision and Disparate Outcomes, Disability Justice Informing Communities of Practice, identifies this as the pathology paradigm. This is the medical legal model of bodies. And Brown identifies this as disablement. And I quote, this is Brown talking. Disablement is how biological and neurological realities, the fact that my brain as an autistic and otherwise neurodivergent person functions differently from those in the room who are not autistic, interacts with social and cultural values about whose lives and bodies and minds are valuable and worthy and desirable, and whose lives and bodies and minds are not. This process and what it produces, the category of disability, is disablement. End quote. And the prevention team in discussions at ICADV, where I work, about that Planned Parenthood FRIES acronym, also brought up the realization that not all humans demonstrate enthusiasm in communication or just in their body language, or even really feel excited about sex, but they still might want to engage in it. And our social expectations about what enthusiasm is and looks like may impact how people read consent socially, and that can impact negatively personal relationships. And so we recognize that this national consent narrative has some able bias. And I want to look a little bit more closely at the concept of consent. Let's consider consent within the context of power and power relationships. As sexual violence preventionists, we should be complicating our discussions. When we talk about consent, are we referring to the social contract or the legal contract? Do we mean autonomy or do we mean legal competency? Is a leveling of the playing field possible? Can a discussion move power to a shared power zone between sexual partners if the context beyond that interaction does not allow for the leveling effect? And I'm just thinking about some really easy examples here, like consent negotiated between a boss and an employee, or sexual relationship between young adult and old adult, or between a student in college and a professor, or even between someone under guardianship and someone who isn't. I know plenty of people where guardianship has destroyed their relationships. The social contract of consent that we teach in sexual violence prevention education is about autonomy, and having autonomy suggests that one is empowered to make decisions that impact that person and the world around them. Legal consent is established within medical and legal systems that have a historical interest in controlling the health of some populations, and including people with disabilities and people of color. And so access to an opportunity for comprehensive healthy relationship and healthy sexuality across the lifespan are inequitable, meaning that some people are disadvantaged by the current legal and medical systems and some are advantaged. And like safety, equitable access and opportunity is not distributed equally. In sexual violence primary prevention strategies, we need to identify and address how power is operating. What motivates the decision to use sexual violence to cause harm? If capacity to make informed sexual decisions is required for legal consent, then what do we do when the information offered by or within systems allows for us to continue to be incompetent? How is power operating there? Sexual violence primary prevention asks us to look at the conditions that make it easy to use violence to take power over someone. We need to be asking ourselves, what are the forces at play excuse me, in the environment that encourage and allow for risk-taking decisions? What do we do with the ethical dilemma that the national narrative and CDC science says sexual health education can prevent violence individually, and there are people who have sexual feelings who will act on them without within a paradigm that infantilizes and isolates and criminalizes full sexual autonomy, or in the case of queer sex, where competent health information is just unavailable. All of this is to say that healthy sexuality education is necessary, but insufficient to end rape culture at the cultural level. Who teaches healthy sexuality education? If people with intellectual and developmental disabilities are at the forefront of that movement, then that would be moving power from the margins to the center. But rape and other forms of sexual violence are population level problems that require population level solutions, and that means making safe, stable, and nurturing relationships easy and expected through environmental, social, and systemic support. Oop. I'm sorry, thank you for helping me. The last webinar, number 1, we addressed isolation as a risk factor for sexual violence and other forms of health impacts. Sexual violence preventionists will recognize the image on the left as the social ecological model. This is actually also called the integrated services model in the field of disability justice and advocacy. So this conceptualization on the left considers the complex interplay between individuals in their relationships within communities and organizations and the societal factors in decision making, compared to, on the right, the paid support model of services. This is an isolation model. And just to remind people, people with intellectual or developmental disabilities have a sexual violence lifetime victimization prevalence of 65 to 98%, according to the best available data, of which there is very, very little. So for violence preventionists, in this dichotomy is yet another reason why we should be partnering with disability services and the advocacy field. Locating our solutions on individuals and relationships allows us to forget that prevalent sexual violence is a population level problem. It oversimplifies the reality that these solutions do not challenge able bias or systems of power and control. What we know is not a great predictor of what we do. When we locate the solution on individual behavior, it does allow us to keep alive and legitimize victim blame. You should have known better than to walk home alone at night, or you should not wear those clothes. So why is this relevant to this conversation? Sexual autonomy is hard for anyone. And in our efforts to prevent violence, we cannot assume that all adult people have the same literacy and knowledge levels. People with intellectual and developmental disabilities historically are not treated as adults, even when they are adults, and are deliberately isolated from other sexual and other important decision making. So some people are not allowed privacy or help to understand their bodies and the sexual desires they feel. Some people are sterilized without consent. You can listen to webinar 1 for more on that historic framework. So humans are also dealing with sexuality changes across their lifetimes. Some periods of life are more or less sexual. Some people feel sexual all the time. Some people feel sexual rarely or never. And all people have hormonal fluctuations that definitely influence desire. Adult bodies with adult hormones and adult desires and brains that use innovative communication strategies are often not given the same basic tools like healthy sexuality education, and well-meaning people run the risk of creating a context to enable sexual violence by keeping humans ignorant of their bodies and what their bodies are capable of. Sexual and relationship education is useful and necessary if it is culturally relevant and accurate, but it is insufficient for cultural change unless it moves power by bringing margins to the center. Safe, stable, and nurturing environments for everyone would help eliminate the motivation to cause harm. In fact, we may actually be doing harm or increasing disparities among adults and youth if we continue to simplify violence prevention strategies and insist that one's decision-making is at the core of sexual violence prevention. For safe, stable, nurturing environments, we have to address the conditions in our neighborhoods, workplaces, educational systems, and communities. We have to address food access and food security. We need affordable, quality education and housing and childcare and healthcare and etc. The idea with sexual violence primary prevention is to create the context in which violence is just not tolerated. We need a cultural context in which the decision to cause harm is not an option that someone would want to choose. That means removing the motivation to take power over someone out of privilege because they can and it's easy, or disadvantage because they're seeking to regain agency or empowerment. And I promise this is my last point for now. Systems change is required, and it's a slow process. Healthy sexuality education for people with intellectual and developmental disabilities must come from within the population and be supported by those with the power to make decisions in the lives of people with disabilities. Kelsey Cowley is going to tell us about her work to address this at the state level. And supported decision-making is a connectedness strategy and a philosophy and a practice that comes from the field of disability services and advocacy. And I am so excited to hear from Melissa and her work about her work at Indiana Disability Rights that I am going to turn over the floor. Thank you.
All right. Good afternoon, everybody. Can everybody hear me okay? Wonderful. My name is Melissa Keyes. I use the pronouns she, her, and hers. I am the legal director for Indiana Disability Rights. We are the protection and advocacy organization for Indiana. Our mission is to promote and protect the rights of people with disabilities, and we do that across a number of different areas. I have been in and around and through and under and over and within the disability community for about 15 years now, and just in different areas. I have a master's in clinical psychology with a focus on autism spectrum disorders and serious mental illness. And I received a law degree from IU McKinney in downtown Indianapolis. So I have a lot of student loans and a lot of letters after my name. But I'm excited to talk to you guys today about guardianship and what it means in the context of abuse. Okay, so today we're just going to cover some guardianship basics. That includes understanding capacity, and then talk a little bit about guardianship and abuse, and focus on some alternatives to guardianship or different options for when somebody is an adult, for them to structure that transition from childhood to adulthood. Okay, so guardianship defined from an outset. So in legalese, it's a legal proceeding to appoint a person who is responsible to the court to take care of an incapacitated individual or minor and or manage that individual's property. And to translate that, it is basically substituted decision making. It means that somebody makes a decision on behalf of you. You no longer have your decisions recognized or respected. There we go. So a guardianship proceeding starts with a petition to appoint a guardian. That is usually done by whoever is seeking to be the guardian. It is accompanied by a physician statement, and that physician statement generally attests to the person's capacity from a medical model context almost. Generally, it includes information about diagnosis and limitations and strengths and weaknesses and things like that. There is notice to the alleged incapacitated person. A GAL or a guardian ad litem should be appointed in every case. Whether that is actually done in practice varies greatly depending on the court and the county that you're in. The GAL, however, makes recommendations regarding the person's capacity, and then if their recommendation is that they are incapacitated, the suitability of a proposed guardian. To be clear, a GAL does not represent the alleged incapacitated person. I think there's sometimes a little bit of confusion with that. The GAL does what's most closely related to as a best interest standard, as opposed to representing the rights of the alleged incapacitated person. And then once all that information is provided to the court makes the final determination regarding that petition, and that could be whether to appoint a guardian, whether to appoint a limited guardianship, whether to not appoint a guardian in lieu of something else, or whether to deny a petition outright. Okay, so guardianship overview. Under guardianship, the guardian makes all legally binding decisions. Now, this is more than just signing paperwork. This means that decisions about where somebody lives, what kind of work they do, whether or not they can get a license, whether or not they can, move apartments or move houses, whether or not they interact with certain people or engage in certain services, all of that defaults to the guardian. The guardian is required to alert the court regarding a change of person's address. They're required to provide regular accounting of a person's finances. However, under guardianship, the person still retains the legal right to vote unless it is specifically and expressly stated in the guardianship papers that they are having that right removed. From a practical standpoint, though, the guardian might still be able to impact a person's right to vote by, restricting their ability to seek out registration, or by, creating roadblocks for them to access voting centers. Indiana law does say that the, excuse me, the person should have choice and independence to the greatest extent possible, but there's really little to elaborate on what that means or how to put that into practice. A guardianship is overseen by the court. So that means that anything major that happens under the guardianship may need court oversight or a court decision. In order to terminate a guardianship, you have to demonstrate that the person is no longer incompetent, or it's at the person's death. At a guardian's death, a successor guardian should be named. It doesn't terminate the guardianship itself. Okay, so understanding guardianship. Parents, when they are dealing with, their 16, 17-year-old child, are often led to believe that guardianship is the only option to remain involved in their child's life once that child turns 18. They're often led to believe that they will be unable to participate in education decision-making, they will be unable to participate in medical decision-making, and that the only way to ensure their ability to participate is to seek guardianship. And that is not true. There's a range of options that are available. There's also a tendency to seek guardianship if the person can't be 100% independent. And this goes to thinking about capacity as an either or. And when you think about capacity, you have to ask yourself, capacity for what? Capacity to make a certain decision in one context may be different than the capacity needed to make a decision in another context. So there's a tendency within the disability world to view it as an all or nothing, when really there is a gradation and a range and a spectrum of a person's abilities. There's also sometimes a paternalistic presumption that disability means that you have an inability to make decisions, or that if you've ever made a bad decision and you have a disability, that is indicative of you not ever being able to make a correct decision in the future. Approximately 89% of Indiana guardianships are full or plenary guardianships, despite courts having the power to limit. Oftentimes it's used as a default or an automatic granting of full guardianship, especially when it's the parents that are seeking guardianship. Now, studies show that a lack of control and a lack of autonomy can be anti-therapeutic. And this is really integral to the discussion about guardianship in the context of abuse, because not having control, not having autonomy, not having self-determination can really prohibit somebody's ability to advocate for themselves and advocate for what it is that they want. And also wanting to make clear that decision-making is a learnable skill. So when you think about capacity, thinking about it as an opportunity for learning new skills to be able to have that, be able to build that skill base so that you are able to make decisions and have those decisions respected. Okay, so understanding capacity. Someone who is, the legal definition is someone who's unable to manage his or her property and or provide self-care due to, and there's a number of different reasons. One of the, insanity, mental illness, mental deficiency, physical illness, and these are in statute, these are not my words. And then the second one is have a developmental disability as defined in Indiana code. One thing that I want to make absolutely clear is that diagnosis alone should never determine capacity. Whether or not you have a certain diagnosis or a certain label does not indicate what sort of strengths or weaknesses that you have. You need to look at the individual as a whole. Again, capacity exists on a spectrum depending on the context, the situation, whether a person is experiencing active symptomology at a certain point. So it's a fluid and gray, messy concept, which I know attorneys don't like always, but and then capacity may be regained through training or assistive technology. And the thing to understand about capacity from a guardianship standpoint is that it's a different legal standard than consent. It's a different legal standard than informed consent. It's different than a legal standard to be able to consent to contract. So understanding what it is that we're talking about in that context of capacity is also important to the discussion. So looking at capacity to consent. So in Sierra, I talked about this, about with respect to people with disabilities, a person commits a sex crime if the victim is so mentally disabled or deficient that consent to sexual intercourse or other sexual conduct cannot be given. And let's unpack that for a second, because I think, aside from the poor choice of language in the statute, which we have little control over, determining what is so mentally disabled or so deficient, and what it means where consent cannot be given, we need to look to some case law. And unfortunately, there's not a whole lot to pull from, but there is a 1983 case from the Indiana Court of Appeals that dealt with this issue. And the standard that the Court of Appeals came up with was that consent presupposes an intelligence capable of understanding the act, its nature, and the possible consequences. And when you think about that in the context of disability and where that definition might fit into people's presuppositions and stereotypes about what a person with a disability can or cannot do, it really frames that issue of whether or not somebody does have, capacity to consent for purposes of determining whether a sex crime has occurred. Okay, so guardianship and abuse. One thing to be clear, guardianship is not a shield, it's not a chastity belt, it's not a bank vault. Guardianship is never a solid 100% guarantee that someone is going to be completely safe. The key is to ensure that the person has the best possible tools to stay safe. And that comes from increased independence, increased self-reliance, and not from taking away decision-making authority. The more often that you have time to practice those skills, the more often that you have to make sure that you have the tools that you need to be able to advocate for yourself, the better that you will be. And there are studies that demonstrate that as well. There's a particular study that I want to make sure to point out to people, and it is from the American Journal on Mental Retardation. And again, not the best choice of language, but it's a study that looked at women with intellectual and developmental disabilities. And when they were provided with education and self-determination, it showed that they were more likely to identify abusive situations and less likely to suffer abuse. And I think that's something to consider both within and without the context of guardianship. So even if somebody is under guardianship, there needs to be in place mechanisms to promote that self-determination. When I talked about earlier about looking at the Indiana standard that says that you're supposed to allow the person to practice, independence as much as possible. That is really key to being able to address abuse, and that's something that we should consider when we're talking about abuse within the context of guardianship. So another thing that I want to talk about, and I've talked a lot about capacity being a continuum, and I wanted to really point out that it's not just you have to be completely independent or you need to be under full guardianship. There's really a range of options available to structure to help support somebody so that they can live in the least restrictive, least intrusive manner possible. So when you think about it under a context, and you think about something like supported decision-making, which for those of you who are not aware, supported decision-making is both a concept and a practice, and it harkens back to just the general human experience of how we choose to make decisions. We don't make decisions in a vacuum. We seek out friends and family members, we seek out professional advice, we seek out experts, we combine all that information, we mull it over, and we make a decision, and as normal everyday human experience, we have that decision recognized and respected. For people with disabilities, that hasn't always historically been the case. There's a tendency to presume that people with disabilities are unable to make decisions, or that if the person posing the decision disagrees with the person's decision, that the person with a disability is unable to make a decision because they don't agree with them. So there's lots of history and context behind what it means to be able to make a decision and have that decision respected. So when you think about supported decision-making as a concept, it's really just how to support somebody in making life's tough choices. And when you think about it from a formalized supported decision-making context, what that really is you are, the person with a disability surrounds themselves with a team or a group of people that they respect, that they rely on, that they choose, and that team is available to help them make some of those choices. And when I say help them make some of those choices, I want to be absolutely clear that the person with a disability under a supported decision-making model retains the right to make all decisions. The supporters are there to support. The supporters are there to serve in whatever way the person with a disability has identified. That could be anything from being a sounding board to helping the person filter out what is good and bad information that might be needed to make a decision. It could also be, if the person wants certain help, to be able to help communicate that person's wishes. The key is that it is directed by the person with a disability. And I also want to make clear that supported decision making is, while it shares some of the same philosophy and grounding in things like person-centered planning and individualized and that type of understanding in the disability services context, the difference is that supported decision-making is person-directed, not person-centered. And I think that's a very key difference between them. So when you think about the spectrum of everything from complete independence all the way up to full guardianship, there's really a range of opportunities. There's independence and informal supports. This could be everything from, setting up bank accounts that have limits if a person is worried about, financial concerns. There's ways to set up trusts, and there's ways to set up, people can sign HIPAA releases to allow somebody to come into medical appointments with them if they so choose. There's formalized supported decision making, where the person is surrounded by a team that helps support and empower them to make their own decisions. The next level up is agency agreements. Those are things like power of attorney, healthcare representatives, representative payee, things like that, where in certain circumstances, somebody does have the power or authority to make a decision on your behalf. There's different levels of consent and different levels of quote unquote capacity needed to be able to enter into those, but that is also another option. There's also limited guardianship, where a court could limit the scope of what a guardian is allowed to do. And then there's full plenary guardianship, where the guardian retains the decision, or the guardian obtains the decisions over both the person and their estate. One thing that I want to note about agency agreements is oftentimes those can be incorporated within a formalized supported decision-making model. Now, one of the things that we talk about is there's an option for what's called a springing power of attorney, and that basically, in essence, says under certain circumstances, under this circumstance X, the power of attorney springs, and this person is authorized to make a decision on my behalf. Now, the problem when it comes to people with disabilities is that oftentimes it is presumed that the springing power of attorney has sprung, and the default is to look at that power of attorney agreement and still focus on the supporter as the decision maker instead of the person with a disability. So again, formalized supported decision-making, the person retains legal decision-making power. That is the absolute key and crux of the decision-making model. The person chooses supporters, the person decides the areas where the support is needed, and the person decides how help should be given. And then under a formalized model, it's formalized into a written agreement, and that is one of the things that we are studying, that we worked on with our case with Jamie, to have her create a supported decision-making agreement that would allow her to no longer need a full guardianship. So who can use supported decision-making? Anyone. And I say that with a caveat. The concept of supported decision-making is available to anybody in a decision-making arrangement. You can always learn and increase your skills to be able to increase your ability to make decisions. Formalized supported decision-making as an alternative or as another tool in the independence to guardianship spectrum It's for people who really want to maintain independence but just need a little formalized assistance. So when you think about people where the parents are seeking guardianship just to be able to have input on their child's life, or they're seeking guardianship just for the purpose of handling certain paperwork, or they're just seeking guardianship to prevent somebody from checking themselves out of a mental health institution, those things you should really maybe consider some alternatives when you're looking at guardianship as just a band-aid to address a certain immediate need that could be better addressed through less restrictive means. And then of course, somebody who is not legally incapacitated with or without support, that is another component to it. I went through really quickly because I really want to make sure that there's time for discussion and questions. Here is my contact information if anybody is interested in learning more about guardianship or supported decision making or our project. And with that, I am turning it over to Kelsey.
Can everybody hear me? Hi, my name is Kelsey Cowley. I am the Sub-Advocates of Indiana president. I live in Avon, Indiana. I am involved in my local advocacy group, also my side advocates. I also serve as a representative of SAI on 12 boards in committees. Sub-Advocates of Indiana. I am here to talk about guardianship and the impact of guardianship on my personal life. My parents established guardianship over me when I turned 18. They felt like that they needed to do this in order to help me make decisions, specifically in the area of money and finances. She felt like that was the only choice to help me in this area. Although I am under guardianship, my parents allow me to make most of my decisions. But that isn't the case for everyone under guardianship. Specifically, when it comes to sexuality and relationships, which is why I want to share why I wanted to share today. I also have experienced sexual violence personally from my biological dad when I was 5, which has affected me in many ways. And so I think it's important for people with disabilities to be educated about sexuality and relationships so that they can advocate for themselves and make choices regarding sexuality and relationships. I currently am working on a toolkit to help other self-advocates and self-advocacy organizations to address the issues of sexual violence against people with disabilities in their communities, from educating the community and individuals with disabilities to change policy and practices. First of all, I should say that I am not a legal expert, and I'm speaking from personal experience and the experiences of some of my friends. Guardianship can affect people differently, and it depends on the guardian. As I mentioned, my mom lets me make a lot of my own choices. I make my own choices about my relationships and sexuality, where I go, what kind of medicine I take. I also go to the doctor's appointments on my own. I do a lot of independent, I do a lot independently without her input. However, it can still be frustrating to not feel like I have the ultimate choice. My mom has taken my car keys and my cell phone away before, sometimes for my own safety. But it can be frustrating. Currently, I would like to move out and move in with my boyfriend, but my mom feels like I am not ready. So that is one area that the guardianship stops me from doing what I specifically want. Some people have guardians who have a lot more control over their lives. Some might not even allow them to date or have relationships. I have a friend whose guardian won't allow her to be married or be independent or intimate, with her boyfriend. A guardian might also make decisions regarding accessing birth control or termination of pregnancy. Another issue is if the guardian is the person who is doing harm. First of all, a person with a disability might rely on the guardian for their basic needs, like shelter, transportation, and medical care. Under guardianship, the guardian would be needed for medical care and to sign legal documents, which make it more difficult to report or access help if they are being abused by their guardian. I think the biggest issues is the guardianship denies your right to have control over some of the most basic choices in your life. That makes it hard for people to develop decision-making skills. In some guardianships, a person might not have the ability to make choices about what they eat, so it might be hard for them to have confidence about decisions that are more important, like those related to sexuality. Ultimately, being labeled incompetent or incapacitated makes a person feel powerless. That's how it makes me feel. I feel like I am capable of a lot of things. When a person feels powerless, they might not feel like they can speak up when something is not right. Guardianships can also make it hard for people with disabilities to get help and support. Law enforcement, crisis centers, and shelters might not have the resources or knowledge to know how to serve people with disabilities when they try to access help. They might also assume that because a person is under guardianship, they are incapable or unable to explain what they need. Even connecting with law enforcement or a crisis center would be difficult. I am very independent. I am able to drive, and I do not require a lot of support. However, many people with an intellectual disability does not drive and have to rely on others to take them anywhere. Transportation is a huge issue for people with disabilities to access supports and services, especially when they are in a crisis situation. I think guardians and other people can support people with disabilities and help prevent violence against us. It is important to promote decision-making. This can happen even with a guardian. Make sure individuals are included in the decisions about their lives. The self-advocacy motto is nothing about us without us. And even though that is often used when talking about disability policy, it is important for individuals as well. It's important for parents and guardians, even from a young age, to promote independence and choice so we can become good decision makers. It teaches us how to make choices about little things and helps us make wise choices about bigger decisions. Parents often seek guardian in order to protect their child, but it it's important to allow us to take risks. We all know that sometimes you have to learn the hard way, and people with disabilities should have that opportunity too. If we can't make mistakes and learn from them, we might not learn how to identify situations that are unhealthy or unsafe. Encourage us to create a support system who can give us advice, help us make tough decisions, and even tell us when we are making mistakes. We all need this. What kind of support, what kind of support? If we are isolated, our protected too much, we cannot develop those relationships. Work with us to identify people in our life who we feel comfortable speaking about specific topics with. It's not always comfortable to talk to our parents about your sexual relationships, but maybe there is another trusted person you can go to when you have questions about that. Supported decision making is when you identify people you trust who can help you make decisions about different areas. It's really about how we all make decisions. This can be done in and outside of a guardianship. Some states even have laws allowing supported decision making to be an alternative to legal guardianship. We do not currently have that in place in Indiana, but it can still be used as a tool to help identify, to support and empower decision making. And I think I forgot something. No, I did. I'm done.
This was unmuted by the organizer, by the way. Hi, my name is Sky Ashton Kantola, and I use she, they pronouns. I'm one of the organizers for this webinar series, and I'm the program coordinator for the Multicultural Efforts to End Sexual Assault. So with our remaining time, we wanted to get in a little bit into how can providers, colleagues, friends, and guardians better prevent violence against people with disabilities, especially given the opportunities and limitations that we've discussed in the context of legal guardianship. So for this section, I wanted to kind of facilitate a discussion among all of the people who've spoken today. So I'll just pass the mic around and let each person the opportunity to offer one or two suggestions about how providers, colleagues, friends, and guardians can prevent violence against people with disabilities.
Yes, please say your name. This is Melissa. So one of the things that I noticed from listening to Kelsey talk is her referencing, and this is so common within the guardianship context, my parents allow me to, my parent lets me, and that's an inherently disempowering feeling to have. And I want to talk a little bit about the concept of learned helplessness and what that means within the concept of guardianship, where the person has been so disempowered to make any decisions that when they are inevitably faced with a situation without someone to make a decision for them, that they don't have any decision-making skills to fall back on. So it's great that Kelsey has the opportunity to make decisions and have those decisions respected. And I think that that is one thing that within the guardianship context is so important, but it's changing the function and the language of it shouldn't be the guardian allowing somebody to make a decision. It should be the guardian supports the person in making their own decision. And I think that's really kind of an important difference.
Hey, excuse me. Hey, this is C. I have a couple of things that I want to say about what practitioners can do to help prevent violence, sexual violence, and other forms of violence for people with people with developmental and intellectual disabilities. And the first thing that I would ask really is for sexual violence preventionists across the nation to reach out and partner with your local disability services and advocacy agencies, because their need to protect people under HIPAA, which is a federal law that protects people's medical records, misunderstandings about HIPAA will prevent them from reaching out to you. It will prevent the implementation of restorative services for direct support providers who experience workplace violence, that when you've been helping someone for 20 years can feel like family violence or domestic violence. And so I have come to understand that the two fields are natural allies and we are powerful together. And so I just really want to encourage sexual violence preventionists to reach out, because again, HIPAA is going to prevent people from seeking support services and prevention services. And I think what I'd like to talk about next, well, I don't know if it will be briefly, but at Indiana Coalition Against Domestic Violence, we have a violence prevention strategy selection tool. You might call it a decision-making tree called E4. And we are practicing running our decisions through the E4 framework. And I mean little decisions and big decisions about what we do as our work. And so I want to tell you a little bit about the E4 framework. And there is a slide in there, if you get copies of the slides, that will have the E4 framework on it. Essentially, there are 4 questions that we should ask ourselves when we are thinking about the work to do sexual violence primary prevention or other forms of primary prevention. We should be asking ourselves, is this effective? What evidence makes us believe that the strategy that we've selected will work? Research and practice-based and community-based knowledge are valid forms of evidence in making this determination that are often discounted and just not available because of the current standard of evidence base is really hard for communities and practitioners to reach. We don't have enough money to do a formal experimental design, if you will, and practice-based evidence is very important. We should be asking ourselves, is it ethical? Does this strategy place the burden of responsibility on the shoulders of those with the power and responsibility to create changes? So this doesn't mean that members of traditionally marginalized communities should not be in the forefront of these efforts. It means that our strategies should not require vulnerable communities and populations to change their behavior or to do more in order to try to safely navigate the inequitable distributed risks that they face. Privileged individuals and programs and systems should be working in collaboration with diverse leaders to reduce risks and ensure that opportunities to safely thrive are available to all community members. When we ask ourselves, is it efficient? This isn't necessarily about money, but it kind of is. We are all working within a shrinking funding paradigm. And so when we are asking ourselves about efficiency, we're talking about shared risk and protective factors. We are asking ourselves, does this strategy have the potential to impact broad populations or multiple social problems? So with the consideration of our limited resources and the overlap in the risk and protective factors among and between the social problems, it is in our strategic interest to maximize our impact by working at those intersections. And is it equitable? Does this strategy center the voices, needs, interests, and strengths of traditionally marginalized populations? We will not introduce or invest in prevention strategies that result in increased health and safety disparities between privileged and marginalized populations. Did I forget one? Is it ethical? Did I don't know. I believe that I said all the E4s. So those are all the 4 E's. So those are 2 suggestions that I have, and I probably could go on and on and on. I'm going to pass the mic. Kelsey?
Gotta get this right. So the question for providers and colleagues and friends on Guardians better prevent how to better prevent violence and against PWD. Just get from personal experience is to understand the person where they're coming from. Know the person. It's if they want to be the person, if they want to be who they are, don't try to stop them. Like I said, my parents have had guardianship over me since I was 18, and sometimes my mom does try to stop me, and it's annoying. It's frustrating because I'm a lot more independent than I used to be, and it's not easy because, I mean, people who don't have a voice to tell their parents or their guardians. How are they going to tell their friends, their guardians, what they want? How are they going to say, oh, please don't treat me like this? Or how are they going to speak up and try to defend themselves and be an advocate for themselves when they don't have a voice? That's why there's a lot of people out in this world that do what they do. And from the violence perspective, there's a lot of stuff out there that you don't even see. A lot of guardians that are a little bit more restrictive, a little bit more violent. Like I said, my friend, her mom doesn't allow her to have an intimate relationship with her boyfriend and won't allow her to get married. And there's other stuff too, but she also has a severe medical history, but that's still no reason why you should not allow your daughter or son to have a family, have a life of their own. It sickens me when I see families try to control their child that has a disability, and they don't know how to speak up. It's hard to explain. This is one of the things that I've been fighting myself to get my rights back for years, and it's doing a reversal on a guardian is going to be really hard. Once you just think twice before you get the guardianship, because you don't know how it's going to affect the person in the long run, how it's going to affect them, how it's going to affect you, how everything it's like a domino effect if you guys don't think about it. And now It's, I mean, and one of the things that I want to point out, when you got, if there's anybody that has a, that's a guardian, if the person, and this is something to think about, I had to find out the hard way, when I didn't listen to my parents, I can get arrested for it. I can get arrested for not listening to my parents, which is my guardian, which is disappointing because it ruins the person's record. It ruins the person's work record. Ruins pretty much their whole life, and the person with a disability would not last in jail.
Kelsey, I have a specific question for you.
Mhm.
I wonder if you would be willing to talk specifically about the toolkit and some of the things that you're working with on the Speakers Bureau.
So I am part of Self Advocates of Indiana. We're doing, personally, I'm doing a toolkit to help people with disabilities understand sexual violence, exploitation, prevention, picking my brain here. Looking at incident reports, the reporting with the state, how case managers report, and this all stems from my history because of being abused by my father and some recent interactions. And I mean, if you think about it, there's like 96% of people with disabilities are in an either abusive relationship or has been a victim of either rape, exploitation, perpetration, any of that. And it's sad because when you think about it, people don't automatically think that we are capable of having babies. People think that we aren't capable of having a sexual relationship. People don't think that we're capable of being in a relationship, period, or being married. And it's disappointing because when we express that we want to be married legally, we can't, or else we will lose. We will lose our Social Security disability, and it depends on the situation. But like my situation, mine's because of my dad's death benefit, and I will lose my Social Security disability and one of my insurances if I get legally married. And then there is a healthy relationship. We're going off this book that we got from an advocate group that made it in another state. That was the author of that, Catherine McLaughlin. And it's to help people with disabilities understand sexuality, all the body parts, everything about sex, all the organs. It's SAI, Self Advocates of Indiana, is putting a group together where they go around to advocacy organizations and sub-advocate groups and like work centers to present this, to do the presenting, and the people with disabilities will be doing the presenting. And it's going to be nice because we need this kind of thing. I mean, people don't understand that we're actually sexual human beings and we need to be treated like one. And it's disappointing when you hear someone's parent terminated their pregnancy because of the guardian. And has that right, but I mean, that's where in my opinion, the rules need to flip. I mean, the government does not know how it is or understands what it takes to have a disability and what it's like to have a disability. Yeah, that I'm gonna pass it on to Skylar now.
Okay, this is Sky, and I just wanted to also add a couple of things to the question of how providers, colleagues, friends, and guardians can prevent violence against people with disabilities. So I want to start by saying that I'm autistic and have several disabilities, and some of these disabilities I've had my entire life, and some of them have come or developed later as I've aged, even though that sounds weird. I don't know, I'm not even 30. Okay. Anyway, so one of the things I wanted to mention is that when people communicate differently, it doesn't mean that they are unable to communicate, and it doesn't mean that they don't know what they're saying or trying to communicate. And it's really important for people to have an appreciation, not just patience, but an appreciation for the differences in the ways that people communicate their needs and their stories and narratives and everything else. Just because it takes somebody a minute longer than you might be used to articulate their own experiences or something doesn't mean that they're unable to articulate or explain their own experiences. And it's really important. I think one of the most foundational parts of interpersonally working better with people with disabilities is just not interrupting. It's like a rule we've been taught in kindergarten and people still in adulthood often don't follow. It can be really disruptive to interrupt somebody in the middle of their thought or whatever they're trying to communicate. I also want to mention a lot of times if I'm doing workshops and I mention that I'm autistic, I sometimes have parents after workshops come up and they're so excited to meet me because they tell me that they have an autistic kid and they just wish that their autistic kid could be like me, by which of course they mean that they wish that their kid could pass and not look autistic to the rest of the world, whatever that means. And that's always really sad for me because I think that people should be allowed to be as autistic or as different or as visibly or invisibly disabled as they are able and choose. And what parents or other folks often don't see is that passing comes with a very severe price. Me being able to pass as someone who is holistic or not autistic or otherwise not disabled means that I was not given access to services as a kid or mostly as an adult, and that has had severe consequences, but also that in order to pass, that I was taught, especially as a young person, that being authentically myself was wrong and subject to penalty. And so how can people with disabilities understand how to say yes or no their own desires or needs if they're taught that they themselves are wrong? How do you not be yourself and still articulate your needs and boundaries? And on top of that, that very often what that means is a lot of us who have learned how to pass or have been told that that's the ideal of how we should function, means that we spend a lot of time convincing people of our humanity, and that very often that becomes linked. Like if I'm able to communicate the way that I'm expected to based on ableist standards, that maybe somebody will see me as more human, even though that shouldn't be the case. And that in and of itself, I think, is violent. And just allowing people to exist as they authentically are and being willing to celebrate the way that people authentically are goes a long way towards empowering people and preventing violence in and of itself. And then the last thing I just wanted to mention was that I think it's really important in doing disability justice and violence prevention work to understand that independence is a lie. Nobody lives as an island or entirely independently. It's just that certain types of interdependence are more socially acceptable than others. It's really weird to me that it's really weird to me that parts of my life are weird to other people. For example, like I can be a state level educator, but I have a lot of difficulty going to grocery stores because the lights are loud and there's too many people and things to pay attention to. And so I'm very fortunate to have a really awesome partner who we like collaborate in the things that we need done in our lives. But a lot of people aren't afforded those types of support for a lot of the reasons that Cierra articulated in the first webinar about isolation and stuff. But it's important to realize that as folks have talked about on this webinar and our last one, and we'll probably continue talking about, that living in interdependence is amazing, and it shouldn't be looked down upon. Independence is not a healthy goal for anybody. It's important that we learn to enjoy living together and recognizing that no person can wholly meet all of their needs alone somehow. And that an extension of that also means that our ability to work and contribute to economies does not define our humanity. You know, whether or not someone is able to work or financially contribute to their well-being doesn't make them more or less of a person or a human. I think I'm going to stop there and just pause and see if there's any questions. Okay, there's no questions, so.
Hi everyone, this is Kirat again. I just want to say thank you to all of our wonderful contributors and collaborators for sharing so many great insights today. As Sky said, we do not have any audience questions submitted at this time, so I'm going to go ahead and close out. If you do still have questions that you're not comfortable sharing here, or if you think of something later, please do feel free to reach out via email. We will be sharing all of our contact information afterward, so you can address your question appropriately. But thank you all so much for tuning in and taking time out of your busy schedules to prioritize disability justice. I know that we all have so many different commitments, and you taking the time to be here today says a lot, so thank you. When you leave the webinar today, a short survey will appear. We ask that you complete the survey to help us gather information to better serve the community in preparation for future webinars and to evaluate our performance on today's webinar. Please complete it before signing off. However, if you are unable to complete it now, it will also be emailed as a follow-up. Additionally, that follow-up email will also contain a link to a recording of today's webinar and should be available to you within the next 2 hours. Lastly, if you need a certificate of completion for attending today's webinar, please email intern@indianakesa.org no later than 1 p.m. on Monday, July 9th, and our fabulous summer intern, Sam, will get a certificate emailed out to you. So that concludes today's presentation. We hope you will join us again today at the same time, 1 to 2:30 on July 11th for webinar number 3 of this series with new speakers and content focused around advocacy and survivorship. You can visit indianakesa.org or visit either MESA or ICADV's Facebook pages to register for that. On behalf of our entire team, we hope you have a fantastic rest of your day.